Welcome back to this week's episode of The Emily Show. We need to talk quickly about Tom Girardi getting denied. And then, well, we've been needing to talk about music. This isn't where I thought it was going, but this is exactly where it's going.
Barker got a weird case. Why is he around? Certified lover boys, certified pedophiles. That fuck 'em
Is
up.
it defamation?
I'ma do my stuff.
We got to talk
Why
about
you
it.
chillin' like a bitch? Ain't you tired? Trying to strike a chord and it's probably A minor.
Yep. Drake's big mad at Kendrick Lamar, though he's not going after him directly. So we need to talk about everything that's going on with Drake finding out IRL what the Streisand effect is. And that's what we're talking about today. We should probably just get into it before all of the platforms are mad that I'm sampling music. Emily, are we pushing as close to the edge as humanly possible? No, it's legal commentary. How can we evaluate if music is defamatory if we can't listen to the music ourselves? Plus, it's an absolute bop. And yes, I'm way too old to be saying that. Don't care, because we are now getting into December and we only have a few episodes of the Wednesday show left. So as we discussed at the 5-year anniversary of the Wednesday show, at the beginning of November in 2025, we're going to be going to 3 days of live streaming, and the Monday show being the only pre-recorded podcast that is going to be out for you. I am so excited for the change. I know you are too. There is so much court we are going to be covering. The Monday show will keep us all in the loop when court is busy, and then 3 days of streaming when court is not busy, and honestly, 5 days of streaming when court is busy. So let's get into today's busy day of podcasting. Welcome to The Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. So can we all just agree that it's kind of rude that it's dark at like 4 p.m.? Because then I want to go to bed by 6 and my family is still like, what are we doing for dinner? Well, thankfully, we have today's sponsor, Green Chef, delivering all of our meals weekly. So what's for dinner in our house literally consists of my teen picking out a recipe card from our Green Chef meals for the week and deciding what we're having. Sometimes he just makes the whole meal by himself because it is that easy to follow. And Green Chef delivers fresh produce and organic ingredients right to your door. And what I love is that I will experiment with recipes I would never create on my own. And each week you'll find recipe options from all different types of eating styles, whether you are just veggie powered or looking for protein plus gluten-free to keto. Green Chef has it handled. Did I mention you can also customize how many meals you get a week? And you can change it up week after week. Some weeks you might need more, some weeks you might need less, and that's all good. Make life easier for yourself and go to greenchef.com/EmilyBaker50 and use code EmilyBaker50 to get 50% off your first box plus 20% off your next 2 months. This deal will have you covered through the holiday season. That's code EmilyBaker50 at greenchef.com for 50% off your first box plus 20% off your next 2 months. Get ready to find out for yourself why Green Chef is the #1 meal kit for eating well. Let's get back to today's episode. Well, as you know, Tom Girardi pushed his sentencing date back to the very end of December. He was supposed to be sentenced on December 6th. And in the course of all of the litigation for Tom Girardi's sentencing, his lawyers also filed a motion for new trial, among other things. They wanted a new trial based on the fact that he was found competent and a new trial on other grounds. I covered that in past episodes. Everybody is kind of Girardi fatigued at this point. I get it. And then they put his sentencing date right over until after the next status conference in Illinois. So we're not going to know what's going on with that prosecution just yet. His CFO has already taken a plea deal. His sentencing has been put over. Is this the end of the Girardi fraud case? Will more prosecutions come? I don't know at this point, because generally they look to get to the tip of the spear. And with the Girardi Keese law firm, it's Tom Girardi. But the bankruptcies are still ongoing. Those are not done yet. And this criminal proceeding is just one more link in the chain. The big question is, What will he be sentenced to? And will he be sentenced to prison, given the fact that he is in his 80s? And even though it's been found that his cognitive issues are feigned, it doesn't mean he doesn't have other age-related health considerations. And will they actually put him in prison? That is what I am waiting to see. I was going to go to LA for the sentencing, and then they bumped it all the way back up to the Christmas holiday. And I'm like, really? No. We'll see. It might get put over again. And then even when he does get sentenced, it's highly unlikely that he'll be taken into custody that day. Like other federal cases you've seen, like the Jen Shaw case and others, there will be a sentencing date, and then there will be a surrender date down the road. Sometimes those are as much as 6 months out. They generally aren't at the time of sentencing. So let's take a look at what the court had to say to Tom Girardi. This is coming from the court's order as of December 2nd. This is the order denying the motion for new trial. The judge says this matter came before the court on defendant's motion for judgment of acquittal and motion for new trial. The court vacates the December 6th hearing in this matter. As set forth herein, the court denies both motions. Sentencing remains on calendar for December 20th, 2024 at 1:30 p.m. The motion for JOA, the defendant moved for the JOA, asking essentially for a judgment of acquittal that no rational trier of fact could have found that Tom Girardi was guilty. Then the court lists out the elements for wire fraud and says there is sufficient evidence as to each element. As to the first element, both testimony and documentary evidence support an inference that in the manner described in the indictment, defendant devised and or participated in a plan to defraud clients to whom he provided legal representation. And then the court goes on to break down all of the different facts that came up during the trial. What I am interested in looking, because JOAs are very rarely granted, it means no juror could have found someone was guilty beyond a reasonable doubt. The elements weren't even proven here. But on the motion for new trial, that is where he was arguing cognitive decline and asking for a new trial based on the fact that the court did not grant his competency motions. On the motion for new trial, the court says that the defendant moves for a new trial, focusing on his competency, and lists out the rules under Federal Rule of Criminal Procedure 33, saying that a conviction may be vacated and a new trial granted when the interest of justice so requires. For example, a new trial is warranted where the evidence weighs heavily against the verdict. And then the court gets into the defendant's competency to stand trial, because he was trying to have a go at this again, and that's what the government said. He's just trying to relitigate the exact same stuff. Nothing has changed. Defense counsel continue to contend that defendant was incompetent to stand trial. They argue correctly that the mental competency of the accused must persist at all stages of the criminal proceeding. Nevertheless, as set forth below, the court rejects the notion that defendant was incompetent during his trial. The court lists out the legal standards, saying a mentally incompetent defendant may not be tried, and defines that as someone presently suffering from a mental disease or defect, rendering him mentally incompetent to the extent they are unable to understand the nature and consequences of the proceedings against him or to assist properly in his own defense. The court goes on to say in the pretrial competency proceedings that the court conducted a 3-day evidentiary hearing and issued a 52-page opinion discussing the defendant's competency to stand trial. Tell me you're in federal court without telling me you're in federal court when the judge is like, we issued a 52-page ruling. Why are we doing this again? As the court previously concluded, defendant suffers from a mild to moderate cognitive impairment that is slowly, that's my italicized voice for all of you just listening in the background. Yes, that italices is in the original. Slowly progressive, but that, quote, defendant is exaggerating his symptoms and partially malingering. Defendant is able to understand the nature and consequences of the proceedings against him and to assist properly in his defense. The court is like, I said what I said, and you are not going to change that because I said what I said. The defendant suffers from some cognitive issues, and that is not in dispute. And the experts who treated and/or examined defendant agreed generally that this assessment had support. And the reports of defense counsel about defendant's behavior and statements during trial are consistent with a cognitive disorder. But in their under seal filings, defense counsel report behavior and statements that suggest a much more severe cognitive disorder. These reports highlight the fundamental issues from the pretrial adversarial competency. Was and is defendant exaggerating his symptoms for secondary gain? That is defendant making statements and or acting in a manner that he understands will support his claim of mental incompetency to stand trial? The court concludes now, as it did in the competency order, that defendant is exaggerating symptoms of a mild cognitive impairment in order to support his counsel's claim that he is incompetent to stand trial. The court does not reach this conclusion lightly. How many times, counsel, would you like the federal judge to say that your client is faking and exaggerating his symptoms? Because the court's going to do this all day. And the court said, I do not come to this conclusion likely. Judges don't want to believe that somebody would come into court and pretend like this. You know what else judges don't want to believe? That a lawyer would do this to their clients. No one wants to believe that this could have happened. But the evidence has been proven and is largely uncontroverted and offensive to all notions of fairness, of dignity, and of what this profession is supposed to be. The court goes on to say, defendant's first claim of cognitive impairment arose in December 2020 as Girardi case lost financial liquidity due to the pandemic and as defendant's co-counsel in the Lion Air case sought a contempt order from the Northern District of Illinois. The court discussed how numerous contemporaneous recordings, including video recordings and writings, some discussing legal matters, from late 2020 to early 2021 showed defendant had baseline cognitive functioning at this time, suggesting both that the claim of mental incompetence began as a ruse to avoid consequences for mishandling the Lion Air settlement funds, and casting doubts on reports of defendant's poor cognitive function in early 2021. And the government expert assessment reported atypical patterns of claimed memory loss, behavioral, and confabulations that led the experts to conclude unequivocally that defendant was at least partially malingering. For instance, defendant was unable to remember topics where such inability would benefit him, such as his memory of the nature of the charges against him. In contrast, defendant discussed the charges in an insightful manner when those were presented to him as hypotheticals. The experts noted atypical patterns of memory loss that included retention and memories of then recent events, the early months of COVID-19, but also included the loss of memory of historical events, which are generally considered crystallized knowledge that are not as vulnerable to forgetting. He also showed an atypical pattern of confabulations, and those tended to benefit him as well. Additionally, defendant's behavior suggested to one expert that he retained the ability to form new memories, as demonstrated by defendant retrieving from the dirty laundry a particular sweater he favored for visits with experts. And in an example that played out before one of the experts in real time, defendant first claimed to not remember his wife of 20 years, but when he answered a telephone call from her, he clearly remembered not only her, but also accurately recalled details of her schedule and travel. In the end, one expert concluded that malingering is simply the only reasonable explanation for defendant's clinical presentations and test results. And yes, the wife that they are talking about is Real Housewife of Beverly Hills, Erica Jane, or Erica Girardi. I don't know if she's going to change her name. That divorce is still being held in the courts because Tom Girardi is in a conservatorship, and the divorce has not been finalized because of it. So I wonder if at any point she will change her name. But it's interesting that Erica was calling him while he was meeting with one of the experts, and he answered it and had a full ass conversation with her, even though he pretended he didn't know who she was. The court goes on to say, quote, the court finds it far more likely that defendant was simply feigning a complete memory loss to support his continuing claim of mental incompetency. It goes on to say defendant's mental competency to stand trial was also established by his own testimony. Defendant told the prosecutor he recalled hearing testimony from 2 witnesses. He demonstrated the ability to track his own testimony as a possible explanation as to why all funds may not have been paid to a particular client. He stated several times that there was a danger in providing the young client with a large sum of money all at once, especially in light of the client's purported drug problem. The court goes on to say several times when wanting to emphasize a point, defendant would address the prosecutor directly and remind the prosecutor that he had made a particular point before. And by way of example, the court put in a quote, "As I told you before, I don't take a salary." No, you just took the money and paid the American Express bills. The court goes on to say that defendant demonstrated an awareness of the nature of the proceedings as he testified. Near the end of the prosecutor's cross-examination, defendant had the following exchange with the prosecutor. "Sir, you spent your career persuading people, right?" This is the prosecutor to Tom Girardi. Answer: "I don't know. We will find out." Question: "What do you mean by that?" Answer: "I was looking to the jury." Question: "Right. Because you're hoping to persuade them to believe you, right?" Answer: "I don't want to persuade them to believe me. I want them to believe me." That is not the testimony that tracks with how Tom Girardi has presented his cognitive ability. It's also not surprising testimony given everything we've learned about Tom Girardi as a person. But it tracks to me that he would say exactly, "I don't want to persuade them to believe me. I want them to believe me." Tom Girardi in his head is thinking, it only takes one. It only takes one juror to believe me. And I'm going to look them dead ass in the face and tell them that I am in fact trying to persuade them. Yep. Wild. The court's not done though, and says, moreover, the court observed defendant taking copious notes during trial, specifically addressing the issues of competence. The court offered to examine these notes, but despite multiple other in-camera proffers regarding defendant's competency, his notes were not submitted for examination. The court: he was quite extensive in his note-taking. Those would be the kind of things I would want to see. So the court said to the defense, well, let us see his notes then. Was he writing a grocery list? Was he writing words that made sense? Was he writing about something else? Because remember, the standard for competency is, does he understand the proceedings against him? So why wouldn't you show the judge his notes? Probably because they were lawyer notes of a lawyer disbarred and disgraced, sitting in a courtroom, tracking everything around him that was happening and trying to manipulate what was happening in that courtroom, using his age as an advantage to try to escape responsibility and culpability for the theft of millions of dollars from people who trusted him. And he still doesn't seem sorry. And I imagine that if he speaks on his own behalf at his sentencing, that it will be something like what we saw from Sarah Boone. And if you did not see the sentencing of Sarah Boone, it's because you don't have the Law Nerd app and you were not reminded that I was streaming on Monday, December 2nd to cover the sentencing of Sarah Boone. And if you missed it, it is time-stamped. You need to go watch what she said to the court after you finish this podcast episode. The court goes on to say, overall, defendant testified in a manner that was wholly consistent with the defense case. He testified that any fraud was committed by his co-defendant, and he commented upon the co-defendant's ability to control and divert Girardi Keith's funds due to his work in accounting for those funds. Defendant testified more than once that if he had any incidental involvement in a failure to pay clients, it was the result of mere neglect or oversight, not as a result of an intent to deceive or cheat. Defendant deflected, shocking, more than once the significance of the communications he had with clients regarding their settlement funds, giving seemingly plausible explanations for delay in payment or non-payment of those funds. For all of these reasons, the court finds that the defendant remained mentally competent to stand trial throughout the duration of his trial, and his motion for new trial is therefore denied. Yeah, Judge Stanton wasn't having any of it. She said, "You are a faking faker." I mean, that's a summary. But Tom Girardi will be sentenced. What will that sentence be? I don't know. Could he get prison time? Yes. Could he get home confinement? Yes. But would I be incredibly frustrated with the amount of money that he stole, him not getting prison time? Absolutely. Absolutely will. Do I think it'll be a ton of prison? No. But it should be some. So with that, we will have to wait and see at the end of December what will happen to Tom Girardi next. You know who we need to talk about now? Drake. It is getting into cozy season. We just had our first snow here in Middle Tennessee. And the thing that ruins the vibe is if your undergarments are just not comfortable. And that's where today's sponsor, Honeylove, has you covered, because Honeylove has revolutionized the bra and shapewear game so that you have support and comfort. And yes, you might want to take your shapewear game to the next level before the holiday season so that all of those outfits fit exactly the way you want them to. But do not discount everyday comfort. Honeylove's bras have got you supported and covered without the bra pulling up or pulling down or rolling on your back. You want to say goodbye to uncomfortable underwire to have a bra you can wear all day long. So you have to check out their bras. From your favorite sweater or your coziest lawn-art hoodie, you're going to love it. And don't forget, when you're really ready to just unwind, Honeylove makes my absolute go-to every single night favorite sleepwear. So shop Honeylove's holiday sale and use our link to save an additional 20% off site-wide. That's right, an additional 20% off site-wide at honeylove.com/lawnerd. That's honeylove.com/lawnerd. So go find your perfect fit and don't forget to let them know the Emily Show sent you. Let's get back to today's episode. What the fuck is going on with Drake? Well, he is not yet suing, but he is getting ready to sue in both New York and Texas. And he is going after UMG, Spotify, and iHeart in a couple of petitions where he is trying to preserve or take depositions before filing a lawsuit, which is going to be interesting to see. But these are both things that are allowed for under the various laws of the different jurisdictions where he has filed this. So we're going to go through what those petitions look like, what he's asking for, and whether or not this will resolve. But do you know what I think is really funny about all of this? No, Emily, we don't. You have a whole podcast to tell us what you think. And most of the time you really just tell us what the courts are doing and don't tell us what you think. Well, same, because I've seen this statistic in a number of different publications, including Billboard, that indicate that since all of these petitions were filed right before Thanksgiving, streams for Not Like Us sees a 20% increase in streams and a 440% increase in sales. So has all of the petitions succeeded in, I don't know, exposing anything? Or did it just remind everybody that Not Like Us is a great song and they were like, I love that song? Or did people say, you know what, Drake, you want to sue over it? Fine, we're going to play it more. We're going to do that more. Because the most active way an audience can react is by just putting it on repeat and just streaming the shit out of it. Because of course that's what happens. So first we're going to take a look at the petition that was filed in New York on November 25th, 2024 at 9:59 a.m. Eastern. And while the news started to break before this, that's when the New York petition was filed, and word of the petition in Texas came out a little bit ahead of the 25th. I think it came out on the 24th, but that one is also stamped the 25th, though the media had an unstamped copy. So the media had a copy of that filing, which was probably not well played on the part of the attorneys that are like, the media is going to cover this and they're going to see it our way. So we'll see. But that one did come out technically before the New York one that we are covering first. And this is in the matter of the application of Frozen Moments LLC for an order pursuant to the civil practice law and rules to compel pre-action disclosure from UMG Recordings Inc. and Spotify US Inc. So A disclosure of documents and preservation of documents is what they're ultimately asking for. Nature of the dispute. In his memo to staff reflecting on highlights of 2021, the CEO of UMG, Lucian Grange. Emily, have we talked about Lucian before? Yes, we have talked about Lucian before, and not in the context of anything written by Sarah J. Maas, but we've talked about Lucian in that context as well, just mostly on members only streams. But we have talked about Lucian in the context of Sean Diddy Combs, because when Little Rod Jones, or Rodney Little Rod Jones, sued Sean Combs and his companies, he also sued UMG, and Lucian got sued in that civil lawsuit as well. And though has subsequently, I think, been removed from that lawsuit at this point, that lawsuit got into a side quest of mess between the attorneys for UMG and Lucian, and not so much with regard to Diddy, but most of those civil suits are slowing as the criminal lawsuit is going forward. So back from my diatribe about Lucian, in a memo to staff reflecting on the highlights of 2021, Lucian remarked on it being harder than ever for artists to break through the noise. 60,000 songs are added to Spotify every day. Footnote 1, and then there's a reporting about that. That seems like a lot, but is that still how many are getting uploaded every day now? I don't know. It goes on to say Spotify is the world's most popular audio streaming subscription service. As of the end of the third quarter of 2024, Spotify boasted more than 640 million monthly active users. YouTube laughs at your 640 million, just saying. They've also become the number one place to listen to podcasts based on their numbers, but you know, it is what it is. Spotify boasts more than 640 million monthly active users and 252 million subscribers, and they have footnotes for all of this, including articles about Spotify. Spotify pays music companies like UMG for the right to license songs so it can play them on its streaming service and subscription platforms. In 2023 alone, Spotify paid more than $9 billion with a B dollars in royalties to music labels and producers. Hip hop is one of the most popular genres on Spotify, amounting to nearly a quarter of all streams on Spotify globally in 2023. I will say though, Spotify Wrapped is pretty amazing and I love it. Spotify and UMG have a long-standing symbiotic business relationship. As one of Spotify's earliest supporters, UMG entered into a multi-year global licensing agreement with Spotify in early 2020. UMG and Spotify collaborate on strategic marketing campaigns and products, and in 2024 announced an expansion of their strategic partnership through which Spotify will amplify music discovery and social interaction. There's social interaction on Spotify? Really? Okay. Will amplify music discovery and social interaction and enhance fan experiences across the platform for UMG's family of artists and songwriters. And based on UMG's financial reporting, Spotify paid UMG around $2.2 billion with a B in 2023, which amounted to 19% of UMG's total revenues in 2023. I have questions. They go on to talk a little bit more about Spotify and then begin to talk about Not Like Us specifically, which is the song that I played a little bit earlier, if you didn't recognize it. UMG released Not Like Us on May 4th, 2024. Pursuant to various contractual rights, UMG, via Interscope Records, has exclusive control over the licensing of the song. On information and belief, that's what lawyers say when they think something, but they don't quite know yet because they need to do discovery. On information and belief, UMG charged Spotify licensing rates 30% lower than its usual licensing rates for Not Like Us in exchange for Spotify affirmatively recommending the song to users who are searching for other unrelated songs and artists. Neither UMG nor Spotify disclosed that Spotify had received compensation of any kind in exchange for recommendation of the song. And yes, a discounted rate can be a monetary benefit. It is a benefit in some way. They go on to say they believe Spotify pays UMG licensing fees through wires or mails. So they're like, hey, they're up to shit. They go on to say UMG directly through Interscope also conspired with and paid currently unknown parties to use quote unquote bots to artificially inflate the spread of Not Like Us and deceive consumers into believing the song was more popular than it was in reality. You're going to have to tell me in the chat, in the comments, do you believe a song is popular because of the numbers of streams it has on Spotify? Or do you believe a song is popular because you cannot escape it on short form social media? How do you think a song is popular? Like, what resonates with you? Is it when your friends are walking around going, bah, 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 like, and every reel or short or TikTok or whatever that comes across your For You is using that sound? And then you're like, and now that 30 seconds of that song is forever stuck in my head. But I will say that this song is the only thing that's upended popular out of my brain for like the last 3 days. So there's that. But, and not the Not a Surf popular, the wicked one. I had to clarify, y'all are my age. You know what I mean. They're accusing Spotify and UMG of using quote unquote bots to make the song seem more popular than it was, to fool people. It goes on to say, bots are software programs designed to mimic human behavior and appear to be real social media accounts. Oh yes, we know what bots are on social media at this point. It goes on to say, one individual unknown to petitioner, at this time, this is what they want discovery for, revealed publicly on a popular podcast that Mr. Kendrick Lamar Duckworth's label, Interscope, paid him via third parties to use bots to achieve 30 million streams on Spotify in the first days of release of Not Like Us, with the goal of jumpstarting the song's spread and turning it into a crazy hit on the platform. The whistleblower described Spotify as the easiest platform, quote, to bot, because it does not, like other streaming platforms, have certain security measures when it comes to bot protection. They go on to say that the whistleblower further revealed that on May 6th, an individual affiliated with Interscope sent him a payment of $2,500 via the digital payment platform Zelle, which is owned by a number of banks, and that he was promised another $2,500 and a percentage of the song's total sales for the initial push. And then it links a podcast episode on YouTube. It goes on to say that they believe that UMG hired other unknown third parties to use bots to promote Not Like Us and to inflate the streams of Not Like Us's music video, the video, which UMG first published on July 4th. They say UMG appears to have used similar tactics with other streaming services, and they believe that UMG paid or approved payments to Apple to have its voice-activated digital assistant Siri purposely misdirect users to Not Like Us. Online sources reported that when users asked Siri to play the album Certified Lover Boy by the artist Drake, Siri instead plays Not Like Us, which contains the lyric Certified Pedophile, an allegation against Drake. It's interesting to me that in this, they are in fact saying that that is an allegation against Drake. UMG engaged in similar pay-to-play schemes to increase the airplay of Not Like Us on the radio. Petitioner has obtained information from a third party indicating that at least one UMG employee made payments to an independent radio promoter, a Payola scheme, serving as an intermediary who agreed to transfer those payments to certain radio stations or employees, and the radio stations subsequently played or caused to be played Not Like Us without disclosing that they had been paid to do so. This practice, also known as Payola, is prohibited by the Communications Act of 1934 and has been the subject of regulatory scrutiny by a number of executive agencies. And then it goes on to footnote those. And it says in 2006, UMG agreed to pay $12 million in a settlement with the New York Attorney General following an investigation involving accusations that UMG execs had used a broad array of pay-to-play tactics to secure radio airplay for their music. They go on to say, in connection with UMG's settlement, the then New York Attorney General, Eliot Spitzer, explained, quote, consumers have a right not to be misled about the way in which the music they hear on the radio is being selected. Going on to say, pay for play makes a mockery of claims that only the best or most popular music is broadcast. Separately, in 2005, UMG was sued by two radio promotion companies alleging fraudulent pay-to-play schemes. And then they go through a little bit more of the history of Payola, and they say that they believe a UMG employee employed a similar scheme by paying social media influencers to promote and endorse the song and video. And I don't know if paying a social media influencer to like do a TikTok dance to a song is going to run afoul of the Payola rules at this time if it's disclosed. If it's not disclosed, we got some FTC problems and some other problems. But if it is disclosed, I don't know if that's going to fall under the payola. The law is going to have to evaluate this because getting a song trending on TikTok is more valuable, I think, these days than getting it trending on the radio. They go on to say that they believe UMG paid the popular NFR podcast, which they say has nearly 300,000 subscribers on YouTube and over 330 followers on X, to promote Not Like Us and its video without disclosing the payment. As a part of its deal with UMG, the NFR podcast published podcast episodes, tweets, and other content publicly about the song. In a sea change for UMG's internal policy, UMG removed the song's copyright restrictions on YouTube and Twitch. Hey, look at us. I mean, you know what that means. There's no other option at this point.
I got a weird case. Why is he around? Certified lover boys, certified pedophiles. Wop, 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 wop. That fuck 'em up. Wop, 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 wop. I'ma do my stuff. Why you trolling like a bitch? Ain't you tired? Trying to strike a chord and it's probably A minor. They not like us. They not like us. They not like us.
Just saying.
They not like us. They not like us. They not like us.
It's for research purposes, of course. But UMG is not shy about copy claiming things. So we're gonna test that out. Why not? So they allege that UMG removed the song's copyright restrictions on YouTube and Twitch, thereby, quote, whitelisting the song for the first time in UMG history, which further incentivized influencers to spread the song. Well, that's just smart. That's just a good idea. If you want the song to spread through social media, then you have to allow people to share it on social media. They go on to say UMG's scheme to ensure Not Like Us, quote, broke through on Spotify and elsewhere worked. Not Like Us broke Spotify records as Interscope posted on its X account. And then they talk about Interscope record tweeting, saying that Kendrick Lamar's Not Like Us becomes the fastest rap song to reach 300 million Spotify streams. It only took 35 days. It goes on to say, to date, Not Like Us has almost 900 million streams on Spotify. With 900 million streams when this was filed, I imagine that we're a lot more now. And the latest information that I could find readily and quickly indicates that it has over 915 million streams on Spotify at the end of November 25th. So the day these things dropped, it grabbed another 14 million streams. And because you know I record this with the Law Nerds in the live studio audience, I'm getting directly from the desk from Amaryllis in the chat saying that according to their Spotify, it is now at over 928 million streams. I'm recording this on December 2nd. This song's going to hit 1 billion streams because of this filing. Well, and the other one. So back to them underestimating the almost 900 million streams, almost 900 million streams. Well, we're well past 900 million now. We're almost to 950 million streams as of the recording of this. They say that Not Like Us holds the record for the biggest single day streams of a hip hop song and the most streamed diss track in Spotify history. Wait, it's not It's Every Day, bro? That's not the most streamed diss track in Spotify history? Oh, okay. Footnote 29 has a link to an article about Kendrick Lamar's Not Like Us breaks Drake's Spotify record. Is that what this whole thing is about, really? It says within a week of its initial release, Not Like Us broke the record for the most streamed song in a 7-day period with 96 million streams. After UMG published the video, Not Like Us returned to the #1 spot on Billboard's Hot 100, and in the same week, the song was streamed an additional 53.8 million times and played on the radio an additional 40 million times. From July 4th to August 8th, the video ranked first on YouTube's weekly top music videos charts. Okay. On November 13th, 2024, the iHeart Radio leaderboard reported that Not Like Us was the second most popular song on the platform. Yeah, and when Kendrick Lamar plays at the Super Bowl, it's going to continue to grow. It says on New York radio, Not Like Us remains, as of the date of filing, a top 40 hit on popular music and hip hop stations, including Z100, Power 105.1, 97.1, and Hot 97. From May 9th, 2024 to August 15th, 2024, the song was among the top 10 of all streamed songs in New York City, which is where this is being filed and has jurisdiction. They go on to say UMG touted record-breaking success, and on July 16th, Interscope posted on X that the song had become, quote, the best-selling rap song of 2024 in the US. On July 24th, 2024, UMG posted to its X account that the song charting as the most streamed song of the week. And on August 29th, they also posted to X the Summer Hits 2024 playlist by Spotify. And the caption, Song of the Summer, UMG fam lands 4 out of 5 on Spotify. Birds of a Feather by Billie Eilish, Hot to Go, which is really hard to say without going HOTTOGO. Yeah, it just feels wrong. And then Not Like Us and Espresso. So, okay. UMG is promoting UMG artists on their Twitter account. Wow. They go on to say UMG's scheme to artificially inflate the popularity of Not Like Us were motivated at least in part by a desire of the executives of Interscope to maximize their own profits. You're telling me that record label executives do things to increase their profits? What is the world that we're living in? I am so shocked and stunned that you're telling me that record execs focus on profits. Just insert your own shocked Pikachu face. Are we going to get to anything groundbreaking? Or are we just going to keep saying shit that I already know? They go on to say that UMG executives have an annual incentive program pursuant to which they are rewarded for meeting and surpassing sales and profits projections, among other metrics. Okay. The incentives are largely based on the specific UMG division rather than the performance of UMG more generally. Petitioner has received information that UMG has been taking steps in an apparent effort to conceal its schemes, including but not limited to by terminating employees associated with or perceived as having loyalty to Drake. Here's the beginning of the beef. We have finally gotten through them talking about how successful Not Like Us is, and now we have gotten into the core of the beef. So they are saying that employees associated with or perceived as being loyal to Drake have been fired. They are saying that UMG has demonstrated that it has no interest in taking responsibility for its misconduct, and that over the past several months, Drake has reportedly sought to engage UMG in discussions to resolve the ongoing harm he has suffered as a result of UMG's actions. UMG refused to engage in negotiations and insisted that UMG was not responsible for its own actions. They go on to say, instead, UMG has pointed the finger at Mr. Duckworth, insisted that Drake should initiate legal action against him rather than UMG, and even threatened to bring its own legal claims against Mr. Duckworth if Drake were to pursue claims against UMG. So like indemnity then? And what that means is Drake, well, through lawyers and companies, is saying that UMG said, well, if you're mad at Kendrick Lamar, go sue him for what he said and leave us out of it. We're just the publisher. We don't choose what he says. Go sue him. And if you sue us, we'll sue him. Whatevs. That'll go well. They go on to say, streaming and licensing is a zero-sum game. Every time a song, quote, breaks through, it means another artist does not. UMG's choice to saturate the market with Not Like Us comes at the expense of its other artists like Drake. Drake is Petitioner's sole owner, Petitioner the company, and Petitioner owns the copyright to Drake's entire catalog. Petitioner suffered economic harm as a result of UMG's scheme. They go on to list out the party. Frozen Moments is Drake's company. UMG is UMG. Spotify is Spotify. They go on to talk about the jurisdiction and venue, and they are requesting pre-action discovery, and they give us a little bit of a snapshot of what they might sue for if they move forward and choose to file a lawsuit, because this is a pre-litigation demand for judicial action. They go on to say Frozen Moments has commenced this special proceeding to seek pre-action discovery to allow petitioner to identify appropriate defendants and frame a complaint for a claim under the RICO Act. to identify appropriate defendants and frame a complaint under Section 349 of the New York General Business Law and Section 350 of the New York General Business Law, which are deceptive practices or deceptive business acts and false advertising. So they want to bring a civil RICO claim against UMG, saying that UMG is operating as a racketeering organization. This is also Drake's label. You're going to burn the boat while you're standing in it? Okay, so this is what they are asking for. Petitioner, which is Drake's company, is asking the court to compel UMG to provide petitioner within 14 days of service a copy of an order without notice of entry, documents, and communication responsive to the request in Exhibit A. So they're saying compel them to answer pre-litigation discovery, essentially. At some point, though, we're probably going to see an objection to this by the business entities. They're asking for the same thing with regard to the other exhibits, including preserve all documents and communications regarding the song Not Like Us and all the rest of the things described in the action. And this was filed by the Wilkie Farr office in Washington, D.C. and New York. If you're like, hey, Emily, why does that law firm sound so familiar? They're the law firm that took over from Holland and Knight for James Spear, Britney Spears's yeeted former conservator. That was the law firm that took over for him. It's been so much fun seeing all of you share your new Law Nerd Shop 2.0 merch on social media and telling me in the chat how soft the new hoodies are and how much you love it. And Law Nerd Shop 2.0 was completely built on Shopify, today's sponsor. But so was Law Nerd Shop 1.0. You know, changing everything over from our sourcing and our distribution has not been easy, and it always has some ups and downs, but Shopify made it so easy to change over the website, and it doesn't surprise me that Shopify is the #1 e-commerce platform in the United States. Shopify has the internet's best converting checkout, and what I love as a customer when I shop online is that if I use Shop Pay, I get all the tracking in my Shop app. And then for the Law Nerd Shop, I can use the Shopify app to see it every time you make a Shopify purchase. And it's so much fun to see you loving this drop. So if you are ready to convert your browsers into buyers and get the same checkout that the Law Nerd Shop uses, it's time to upgrade your business with Shopify. You can sign up for your $1 per month trial period at shopify.com/lawnerd, all lowercase. That's shopify.com/lawnerd to get your $1 per month trial period. And you're going to start hearing this sound real soon. And you'll find out why businesses that grow with Shopify. Let's get back to today's episode. I hope you're loving it as much as you love the new Law Nerd merch. And now that we've gotten through the request in New York, it's time to take a look at the request in Texas. This was also file stamped on November 25th at 4:21 p.m. And this is between Drake, under his full government name, Aubrey Drake Graham. And I'm sure we're going to be referring to Kendrick Lamar by his full name, Mr. Kendrick Lamar Duckworth. And it's going to get very confusing. So I am going to call them Drake and Kendrick as best I can, because otherwise I will get confused. And this, like the other petition, is a petition requesting deposition. But these depositions are for a representative from iHeart Media and from UMG Recordings. The other one was a discovery request, turn over documents, preserve documents. This is a deposition request. So we're going to go through it a little bit too, but this is still a pre-litigation, pre-lawsuit being filed request for intervention from the court. So this is their verified petition for Rule 202 depositions. And they start by saying that UMG is one of a handful of companies that dominate the multi-billion-dollar music industry. And when it comes to the release of new music by its most prominent artists, UMG is meticulous in its planning and execution of the music it releases, promotes, and backs with its considerable financial resources. They say that this is not just true because of the amount of money on the line for UMG and its shareholders, but also because UMG's executives are eligible to receive incentive bonuses based on the revenue generated by their respective divisions. Music executives want to make money, you guys. Shocking. Earlier this year, one of the artists that UMG has under contract represented UMG with a new song called Not Like Us. Before it approved the release of the song, UMG knew that the song itself, as well as its accompanying album art and music video, attacked the character of another one of UMG's most prominent artists, Drake, by falsely accusing him of being a sex offender, engaging in pedophilic acts, harboring sex offenders, committing other criminal sexual acts. Specifically, the song calls Drake a certified pedophile, a predator, and someone whose name should be, quote, registered and placed on the neighborhood watch. I mean, that one's a little bit more vague. It does say neighborhood watch and not sex offender list. They go on to say, pursuant to its rights under various contracts, UMG has exclusive control over the licensing of Not Like Us and could have refused to release or distribute the song or required offending material be edited or removed. They say that UMG chose to do the opposite. UMG designed, financed, and then executed a plan to turn Not Like Us into a mega viral hit with the intent of using the spectacle to harm Drake and his businesses and drive consumer hysteria and, of course, massive revenue. That plan succeeded, likely beyond UMG's wildest expectations. And this is when we start to get into defamation. They say UMG released the song Not Like Us on May 4th, 2024, and its music video on July 4th, 2024. They relied on its exclusive licensing right and in coordination with known and unknown third parties, utilized every tool in its arsenal to spread Not Like Us. They said they made it available for radio play, including to iHeart Media, a mass media corporation headquartered in Texas. iHeart Media boasts that it is the #1 audio media company in the US based on consumer reach. Do they consider Spotify a video company? But you also see that Spotify was pulled in New York. iHeartRadio is pulled in Texas. I am just waiting till UMG says, you know what? We're in California. Come get us in California. Because I wonder if the anti-slap laws and some of the other business laws in California aren't as friendly. One of the first things when I look at these is, why are we looping in these other companies to try to get jurisdiction where they're headquartered, not where UMG is headquartered? What laws are they trying to avoid in California? And iHeartRadio is going to be like, leave us the fuck out of this. We want nothing to do with it. They go on to say iHeartMedia claims it reaches 9 out of 10 Americans every month. On their app. Oh no, they own radio stations, don't they? iHeartMedia owns a lot. I forget that they are an umbrella company as well. I think of iHeartMedia and I'm like, oh, like the app? No, they're also an umbrella company for radio stations, like lots and lots and lots of radio stations. They say they have more reach than any other media company in the US. iHeartMedia owns iHeartRadio, a freemium broadcast, podcast, radio streaming, and music streaming platform. Radio stations all over the country, including stations owned by iHeartMedia, have played Not Like Us. And what did iHeartMedia do? Emily, keep reading. Let's see. They're accusing Spotify of bots and Payola, and they're accusing Spotify of having a very close symbiotic relationship with UMG, essentially saying that they're co-conspirators. I'm curious as to what they're going to say about iHeart. They say that UMG, Emily, keep reading. UMG and iHeart have a long-standing symbiotic business relationship where iHeart pays UMG to license and collect royalties for UMG artists' songs. They go on to say, as demonstrated by iHeartMedia's bankruptcy filing in 2018, the amount of money exchanged between iHeart and UMG is substantial. In the last quarter of 2023, UMG, through its recorded music and publishing divisions, had an ownership interest in more than 60% of the 100 songs listed on the Billboard Hot 100 radio charts. On the first week of its release, Not Like Us ranked on Billboard's Hot 100 with 5 million radio airplay audience impressions. I don't even know how they track that. They go on to say in the week that the Not Like Us music video was released, Not Like Us played on the radio an additional 40 million times. I'm going to need you to go back and amend this and let us know how many times it's been played since this petition dropped. They go on to say 4 months later, the iHeartRadio leaderboard reported that Not Like Us was among the top 2 songs with the most plays on iHeart radio stations. They go on to describe essentially the same payola scheme that they complained about in the New York petition, but including iHeartRadio instead of Spotify, and talk about social media personalities and podcasts and what have you being paid. And they go on to cite Rule 202, saying it permits a party to investigate potential claims via pre-lawsuit depositions, and it functions in aid of a suit which is anticipated and ancillary to the anticipated suit. They say that the depositions are governed by the rules applicable to the depositions of non-parties in a pending suit. They say that a limited deposition is the most efficient method for them to understand the role of iHeartMedia in UMG's scheme to unlawfully promote Not Like Us. Based on the minimal information already available to petitioner, the testimony sought is necessary for petitioner to understand and evaluate their potential claims. They're like, we can't even sue until we know more. Because petitioner only seeks this limited testimony, the benefit of allowing petitioner to take the requested depositions outweighs any associated burden or expense to iHeartRadio or UMG. Moreover, the interest of justice is served by allowing petitioner to investigate potential claims before filing, and they say these depositions are necessary as part of the requirements of Texas Rule of Civil Procedure 13 for petitioner to make an informed decision about any future legal action. They are seeking the oral deposition of iHeartMedia via a corporate representative and the same of UMG because they believe UMG provided financial benefit to iHeart in exchange for airplay of Not Like Us. And after they cite their law and jurisdiction, they get to the prayer for relief, which is what they are asking the court to do. They say they are asking the court to issue an order setting date for a hearing on this petition with at least 15 days notice, and after that, a hearing. They want to require iHeartMedia's corporate representatives to testify by oral deposition related to the matters described herein, and they want to require UMG to do the same. So not only did they indicate that there was potentially a Payola-style scheme perpetrated by UMG to promote Not Like Us to the detriment of Drake, but they also said that the things said in the song were something that UMG had control over, could have changed and chose not to. So we are seeing a little bit of a Payola scheme. We are seeing RICO allegations in New York, and then the potentially defamatory rumblings. They didn't say it was defamatory, but they said that Drake was called a pedophile and it caused damage to him and his business. So, you know, if you put those two together, you're going to end up with defamation. And with the words here that are being used, then you might end up in a circumstance where defamation per se applies. However, you're going to get very deep into the realm of artistic context. This is different than writing an article in the Washington Post. This is different than saying something as a fact. Lyrics in a song, especially lyrics in rap songs, have come up quite a lot in courts, not just in civil courts, but in criminal courts, about how much the lyrics can be relied upon. How much is it an assertion of truth? How much is it artistic expression? How much is it hyperbole? And where are those lines? And what are the differences when something is said in a song versus something said in a Washington Post op-ed versus something said on a news station versus something said by a comedian? All of those contexts are different, and the law approaches them in a different way. And what's going on between Drake and Kendrick Lamar is part of a fairly extensive back and forth between the two of them. So there is rap beef here that has spanned across multiple songs. There are tons of videos on YouTube breaking all of that down. If you're like, now I need to know about the 10-year history of the ongoing, if not longer, no, about 10 years, the 10-year history of the back and forth between Drake and Kendrick Lamar that popped up again in, 2024 and is now subject to potentially lawsuits. And then are we going to see Drake sue his own label, saying that they promoted an artist that is defaming him to his detriment? And what does that even look like? So there's a lot of questions here. Looking at statements made in the context of song lyrics is a very different thing from some of the other contexts we've evaluated defamation in. I would love to know your thoughts about this one. I will love to see what happens with whether or not UMG tries to claim the music in this episode. We will see. And I think we're going to see Not Like Us break 1 billion streams before Kendrick Lamar performs at the Super Bowl. So that's what I think. And Drake is going to find out the hard way, much like Tom Sandoval did, that sometimes when you file a lawsuit, the public is on your side and sometimes they are not. And though sometimes in hindsight, it seems like people should know which way that's going to go, there's a lot of money involved in the record industry, and I'm not surprised that we are seeing some legal action move forward. So we will see. Let me know if you want me to keep an eye on this one and let you know when they are filed as lawsuits, if they are filed as lawsuits. There are hearings coming up this week and next week in the Texas case. Are they going to order depositions? Probably not before the end of the year, but are they going to order depositions? We'll see what the court decides to do. Are they going to order the companies to turn over some initial document discovery? We will see, because lawyers need to have a factual foundation to bring a lawsuit. And both of these actions are saying we do have some foundation to bring these lawsuits, but we want more information to bring these pleadings forward and then get into discovery, because the litigation on these is going to be expensive and it is going to be long. And with that, I hope you understand a little bit more about the legal side of what's going on surrounding Not Like Us, Drake, Kendrick Lamar, and UMG. And if nothing else, you might have taken away from this episode that Drake's full government name is Aubrey Drake Graham, and Kendrick Lamar's full legal name is apparently Kendrick Lamar Duckworth. And maybe that is enough of a takeaway from today's episode. But with that, Law Nerd, thank you for being here. Thank you for being a Law Nerd. Say it with me. And then we've got to decide, do we bring the outro from the Wednesday show over to the Monday show? Or does the outro from the Wednesday show stay with the Wednesday show? I feel like maybe it does. So say it with me. May your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. And may the odds be ever in your favor. I will see you in the next one. Bye. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.